Hello and welcome to the Arbitration Conversation. So in this webisode, we're going to explore AI and how AI can be used in or with arbitration. Does it have any relevance in arbitration? And for that, we're bringing in a true expert. I've known his work for a long time in this area and have learned a tremendous amount just by simple conversations. This is Professor Nicolas Vermeys, and he is a professor, he's a lawyer, he's also a certified information systems security professional. Not only that, but he's the Associate Dean of Programs for the University of Montreal and the Assistant Director of the Cyberjustice Laboratory, also located in Montreal. He's also taught at William and Mary Law School, and he's been known as an expert in the area for a very long time. So Nikolai, thank you so much for being here.
My pleasure.
So first of all, could you explain, I mean, there's all this talk, the robots are going to take over, right? And we're going to have robot arbitrators that are going to be deciding everything, and why does anyone even need an arbitrator when they'll all be robots? I'm kidding. Could you explain for us, what is really AI and what AI is actually available and out there in dispute resolution?
So AI is an umbrella term. You have to understand that the whole concept of AI was developed, or the first time we heard the expression was in the mid-50s, when a group of researchers at Dartmouth decided during one summer to study how they could get a machine to act in a way that is considered intelligent, or that would be considered intelligent were a human being acting in the same way. And obviously they were building on the work from Turing from years before, and other researchers as well. And so that was the initial idea of artificial intelligence. It's basically, how do you get a machine to behave in a way that would be considered intelligent were a human being to behave in that same way? Now, I've always had an issue with that definition, simply because it's extremely broad, because using that definition, a calculator is artificial intelligence, right? Because if your 5-year-old tells you, Mom, 5 + 5 = 10, what are you going to answer? Wow, he's really smart. And so saying that it's simply to do something or commit an act or act in a way that would be considered intelligent if a human being were to act in the same manner, I don't think gives a proper idea of what artificial intelligence is. You also have to understand that there are many different forms of artificial intelligence, if you will. What we're talking about right now, and what has been in the media for the last 10 years or so, is what is referred to as machine learning. Now, machine learning is one form of AI, and it's a form of AI where basically, and this is such an overgeneralization that people in artificial intelligence would probably hate me for explaining it this way, but it's basically the idea of having a tool that can learn on its own, like an algorithm that will learn on its own given specific pieces of data. So you give the algorithm access to certain pieces of data, you train it, if you will, and then when you're feeding it new pieces of data, it will recognize it while looking at all the data that was used to train it. So for example, and this is often the example used by those who develop AI, if you have a picture of a cat, the reason they often use a picture of a cat is because on the internet, that's what's there most of, really, because cat owners really love their cats. So there are a lot of pictures of cats. And so if you show an algorithm a certain number of pictures of cats, then after a while, if you show it a new picture of a cat, it will say, well, that's a cat. And if you show it a picture of a dog, it'll say, well, that is not a cat, because I have been trained to recognize what a cat is. So that's basically the type of AI we're using right now, what we're discussing right now in the media. But again, there are other forms of AI. What we've been using in the legal system for years now is what's referred to as expert systems, which are basically decision trees, right? The idea of saying, well, if A, then B, and so on. So those are two examples. If you actually go on the Patent Office website, I believe there's, in the US, I believe there are over 20 different categories of artificial intelligence. My favorite being fuzzy logic, simply because I like the name. But that just gives you an idea of how wide a field of research AI actually is. And when we're talking about AI today, what most people are actually referring to is machine learning.
Right. I like the way you put that in the sort of the different categories, and maybe to give some concrete examples, like for example, an expert system. Is that what you would say? For example, the CRT, when it directs people using a number of questions, would that be an expert system?
Exactly. So when you're talking about current use of AI in arbitration platforms or court platforms, as is the example of the CRT, the Civil Resolution Tribunal in British Columbia. So they have what they call their guided pathway, where a litigant will log on to the platform and answer a question, and then that question will send them to door A and answer a second question, and that will guide him, hence guided pathway, to the right solution. So that's a rudimentary form of artificial intelligence, if you will, and that's an expert system. That's what, again, a lot of these platforms right now, or most of the platforms that claim to be using AI, that's the form of AI, or the type of AI that they're actually referencing, sorry.
So how about the next level, right? So what about this idea of actually having a bot arbitrator, where the decision is actually made by AI?
So that is a position that, if you look at the literature, is referred to as AIDR, right? Artificial Intelligence Dispute Resolution, which would replace ODR or ADR, depending, so alternative dispute resolution or online dispute resolution. And it's the idea to go back to what Ethan Katch and Janet Rifkin referred to as a third and fourth party, right? In a mediation or arbitration context, where you have the first two parties who are the litigants, if you will, and then you have the third party, which is the arbitrator or mediator, and the fourth party, which is the technology, because since technology isn't neutral, it will influence the relationship between the other three parties. And so the AIDR movement is basically saying, well, let's take that third party and the fourth party and let's fuse the two of them together and create a robot judge or robot arbitrator. Now, in theory, that seems interesting for a couple of reasons. First of all, judges or arbitrators are human beings. And therefore, since they're human beings, they have built-in biases because they're men or because they're women, because they're white or because they're Black or Asian or so on. And so everything in their life experience will have an effect on how we see a given situation. And then there have been studies that explain that judges or arbitrators, depending on the time of day, depending on what they ate, depending on if their favorite sports team won the day before, if they lost, depending on if they fought with their spouse, so on, will render a decision that is different than had all the conditions been ideal. And so when you take all of that into consideration, those who are moving towards or suggesting we go into the direction of AIDRs say basically, well, if we have an algorithm is never hungry, it's never cranky, it's never had a fight with its better half, and so on. And so it will always render the same type of decision. Now, in theory, that's true. In practice, there's one issue. The algorithm was programmed by a human being. And so instead of having the biases of an arbitrator who's an expert, who swore to be as neutral as possible and so on, who's meticulously chosen by the parties because of his or her expertise and neutrality, now you have an algorithm that was designed by a computer scientist who is extremely competent as a computer scientist, obviously, because they developed this algorithm. But that individual also has biases, and you don't know what they are, because when the parties are going to a platform, they don't really know if the person who designed that algorithm is a man or a woman, white or Black or Asian, and so on and so forth. And so there is that issue. There's also another issue that we forget when we're talking about a robot arbitrator. And that's the fact that, as I mentioned before, in order for artificial intelligence or machine learning algorithms to be efficient, they have to be trained on data. Now, arbitration, one of the main interests for a lot of people is that, as you know, arbitration decisions are usually not made public, right? It's supposed to be a confidential process. Certain exceptions, obviously, if you're talking about domain name disputes, then those are made available, but most arbitral procedures are confidential. Well, if they're confidential, how do you get the decisions to train your algorithm? And even if you could do that, even if you could find 100,000 cases, arbitral cases that were made public that you can use to train your algorithm, well, then your algorithm is going to make its decision not on the facts of this particular case, because that's not how the AI works. It's going to make its decision based on how the facts of this particular case, how they correspond to the previous cases. So there's a comparative exercise that's being done by the algorithm to see, well, okay, in 100,000 cases, the decision has been so, therefore the decision will be the same in this case because the facts are similar. But they're similar, they're not identical, and that's where usually an arbitrator will use his or her discretion. So we're really not there yet. I'm not saying, I wouldn't dare say we're never going to get there, because you never know how the technology is going to evolve, but currently that's not where we are.
Well, and there is that added problem, as you mentioned, about the data. So let's say you did want to just base it on litigated decisions, because at least you could get your hands on that data. You have the problem with if the data itself is already skewed in a certain direction or is already biased in a certain way, aren't you going to have sort of the garbage in, garbage out problem?
Absolutely. And just to give you an example, I was talking about AI/VR, which I don't think has much promise, at least for the next couple of years. Again, who knows where technology will bring us in 15 years. I would have never guessed I'd have a cell phone that's more powerful than the first computer I owned when I bought that first computer. But for now, what I think has more promise is what my colleagues and I are trying to make a thing, or a word that a term that we use, which is Audrey. Probably because I like Audrey Hepburn and it's a good mnemonic tool. But no, joking aside, Audrey is online dispute resolution aided by artificial intelligence. And I think that has a lot more promise. The idea being that artificial intelligence tools can be used to give context or give more information to the parties. So I'll give you an example just to illustrate that, and that will bring us back to the question you asked. So we developed a platform in Montreal called Parler, and it's currently being used in Quebec and Ontario and in Europe as well to settle online disputes. So it's an ODR platform similar to certain platforms that were developed by Montreal, for example, or other companies or organizations. So our platform is being used in Quebec to help settle disputes, consumer disputes, right, between a consumer and a merchant. And very often the consumer will, as his or her first offer, when you start the negotiation process, overvalue their claim, right? My washing machine is broken and I am going to ask you for $5,000 in damages. Now the washing machine is only worth $300, but I had to go to the laundromat and my time is valuable. And on top of it, somebody saw me there. And I think because of my social standing, I can't be seen in the laundromat, so on and so forth. Obviously, I'm giving examples that are a little ridiculous, but just to illustrate the situation. And so what's happening in these cases is they don't know what their claim is actually worth. And so if they get a counteroffer after that, that is of $200, well, what's the reaction? You're not taking this seriously. I'm asking you for $5,000 and you're counteroffering for $200. Now, if I could have access to data through the platform that tells me, look, there have been 20 cases that refer to washing machines. And in those 20 cases, the value of the case is usually the case is usually settled for an amount between $150 and $500. And the average is more or less $250. Now, I'm not telling you that's what you have to accept. But what I'm telling you is if the other party is offering you $250, there's a rationale behind that. And so the algorithm could help you there. So that's where I think artificial intelligence could be used. But even those cases, you're getting back to your question of, well, how do you pick the decisions? So you still have to decide which decisions are going to be used to train the algorithm. And so we're working on a project right now in Montreal, a chat bot, a legal bot, to help litigants in housing disputes establish what the amount that they could claim is. And so to do that, we got access to millions of decisions from the housing board, or the equivalent in Quebec of the housing board. And we had students structure the data so that you could use it to train the algorithm. But then we had that problem that students would sometimes get a decision and try to structure the data and realize, well, no, there's not enough data in this decision. And so they would ask one of the professors or the people that were supervising, what do I do with this decision? And sometimes we'll say, well, we can't use it in this case because the data is not well structured, or because there's information that's missing and therefore it cannot be used to train the algorithm. So our bias here is not towards a position or not, but we are discriminating against cases simply because the judge didn't mention element X or Y in his decision or her decision. And so even when you're completely in good faith, you still pick decisions. And in this case, the decisions are being analyzed by law students and looked at by law professors. But to get back to the initial question, if you have a computer programmer who, again, is extremely competent in developing AI, and that person is going to choose which decisions it's going to use to train the algorithm, that person doesn't necessarily have the qualifications to know what is a good decision and a bad decision. Usually the only person that can do that is somebody who has legal training, ideally a judge, but at least a legal scholar or somebody that has some sort of training in the field. So that is also a somewhat of a risk.
Yeah, that's really interesting though, when you kind of drill down and talk about how you have to think about structuring and unstructured data, because often, especially when I'm thinking about landlord-tenant, for example, it might deal with relationships. It might be things that are highly subjective to a certain extent. How do you account for that? Because won't it be such that then the data you're using is only in maybe clear-cut cases like non-payment of rent? What happens when it's more squishy, you know, when it is more subjective or perhaps not as easy to define?
Well, that brings us back to the difference between AIDR and ODRE, right? What you're describing is something that is a huge issue for AIDR. You cannot have that element of a discrimination based on context that you would have if the judge or the arbitrator in this case is a human being. Whereas in ODRE, you can simply say, look, in cases where there was a dispute, we're using this data to give you information. And what we're giving you is information. We're not giving you a position. We're also not just giving you a statistic, because that's also the mistake that some people will do and say, well, you have an 85% chance of winning your case. Well, that also means I have a 15% chance of losing. And I mean, what does that mean in the grand scheme of things? I need to know why my case is strong or why my case is not strong. So if you can simply say, look, there have been 10 decisions or 10 awards, if you're talking about arbitration, 10 awards that are similar to your case. These are the differences. These are the similarities. If an algorithm can do that, and then that gives better tools to the individuals, and then they can go and negotiate in good faith if you're in a mediation process, or if you're in an arbitration process, they can actually go up to the arbitration then, or when they show up for arbitration, be better equipped to present their case and their arguments.
Yeah, I really love that. I really like the ODRE idea for a number of reasons. I do think that it's not just giving them a statistic, but also giving, especially when you, in an area, for example, with housing, where you might not be able to afford a lawyer. It could actually be incredibly helpful for access to justice in order to have this additional information to make arguments.
Exactly. And it's also, you know, we're talking about arbitration today, but obviously when we're talking about online dispute resolution, most platforms have that layered approach, right? You start with negotiation. If that fails, you go into mediation. And should that fail, and only as a last resort, then you go into arbitration. And studies show, and I know it was the case for the eBay model, we did the same thing for Parlay in Montreal, usually cases are settled at the negotiation or mediation phase. It's a very small sliver of cases that actually make it up to arbitration. And so the more information you give to the parties to better negotiate and to better understand what their position is, or how strong their position is, I should say, well, then you're making that sliver even smaller. The chances of them needing to go to that last stage of arbitration is even lower, because they are better equipped to understand what the other party's position is and to appreciate if it's relatively reasonable or not.
Well, and I also think there might be other uses. I think as we move along in this kind of brand new world and think about how AI can assist individuals in making decisions, I think we'll probably see maybe more of it in the realm of assisting an arbitrator, perhaps, in making an informed decision. It's not making the decision for the arbitrator, but it is another piece of information the arbitrator could consider in rendering a decision.
Absolutely. We've been talking about these tools for the parties up till now, but you're completely right. These same tools, and we have a huge project that obviously you know of because you're part of it at the University of Montreal, called AGC, or ACT. Autonomy through Cyberjustice Technologies and Artificial Intelligence. And that project, which I invite people to go to our website, ajcact.org, has a lot of different sub-projects. And one of them is using these tools for decision makers, because it's the same thing for decision makers as it is for parties. And that's specifically true in arbitration, because you have more chances of having an arbitrator, especially when you're going into picking an arbitrator that has a specialty in a field, because you don't want to have to hire experts. Well, that person is an expert in his or her field, not necessarily in arbitration. And so to give them these tools to help them understand what the quantums usually are in similar cases and so on, can be extremely helpful to make a good decision. And even giving them access to these tools to evaluate their own decisions is also another way to look at it. Not necessarily for other people to evaluate an arbitrator, but for the arbitrator to self-evaluate and say, oh, you know what? I guess I do have a certain bias, and I should work on that. I should pay a little more attention, or I noticed that, you know, the algorithm pointed out that after lunch, I'm a little more severe than before lunch, so maybe I should take a nap after my meal if I can. So there are ways of using these types of tools to help everybody just be better at what they're doing, help the parties be better informed, help the arbitrator just just hear the case in a fairer manner.
Well, it makes good sense. I guess we really are entering the age of the Jetsons. I don't know if you remember George Jetson, but the Jetsons, they had technology helping them, but not taking over. So maybe that's really the answer.
I'm still waiting for the flying car, though.
Absolutely. And the little thing where the dog runs on the treadmill outside and gets all worn out. Anyway. Well, listen, this has been really informative, super helpful. Thank you so much for taking the time to talk with this. I mean, you have such a great way of explaining it. This is super helpful. So really, thank you very much.
It was a great pleasure. And again, if your listeners want more information, please log on to our website.
Oh, yeah. Can you say it one more time?
Yes. So it's ajcact.org.
Okay, perfect. Thank you very much. Have a great rest of your day.
Thank you.